Welcome, welcome, welcome back and welcome in. Happy New Year to everyone. It's so great to be here in a new year. And boy, that happened fast, didn't it? 2024. Thank you all for being here, for sticking with us. We've had some email issues throughout the last quarter of 2024, and I think we lost some portion of our audience. We appreciate you being here with us today. Those of you who've been with us know that this is approved by the Alabama Board of Nursing and the Alabama Board of Social Work Examiners and is 1.0 contact hour. In order to receive, Happy New Year, Ms. Lynch. In order to receive the contact hour, you must do an online evaluation, and it's password protected. The reason we password protect it is that by doing so, the Alabama Board of Social Work says that this is a live hour, like a classroom hour or a face-to-face hour, and it is an hour in which we do encourage discussion. So we want you to ask questions. You're welcome to raise your hand and I'll unmute you, or use the chat room and ask questions and get all of the answers that you need from today. That's the point and the purpose. We exist, CarePatrol does, to educate our clients and others, including you, about the various options of aging care. We're paid by the providers, and we depend on your referrals. And we've seen so many referrals from our ongoing audience, and we appreciate you. Let me read for you now the evaluation link for today. And today's topic is avoiding probate. Bill Nolan is our presenter. He's been with us many times, is a wealth of information about elder law, and in fact has been practicing elder law since 1982. So one of the first practitioners, and what at that time was a new discipline in law. And now, of course, that discipline benefits so many people. Our evaluation link, now that everybody is sort of in with us, is https://www.surveymonkey.com /lowercase r / all uppercase letters, F as in Frank, B as in boy, Q, H as in Harry, X, H as in Harry. That's our evaluation link. Again, we give the code out at the end of the day. I've posted the evaluation link into the survey for you. And just one other thing, if you are of the nursing discipline, we'll be posting your hour for you once you've completed the evaluation. Everyone will receive a certificate who does the evaluation, and with Bill's permission, we'll be sending the PowerPoint out as well for your use and files. So without further ado, Bill, thank you so much for being here. Happy New Year, and let's learn about avoiding probate.
Sean, thank you for inviting me back once again. It's always a pleasure to speak with folks on your list and answer questions. This is probably my favorite part of practicing law is the marketing interactional aspect. So thanks for giving me another opportunity. Today, we're going to talk about a topic that comes up a lot. Now, it may not come up with some of you because you're younger, but it may have come up in your family, even if you are younger. There is a common phrase that is uttered over and over and over out there, and it has to do with avoiding probate. Articles, magazine articles, radio shows, podcasts talk about avoiding probate. Well, why? I guess the biggest question is, why would I want to avoid probate? What's so bad about it? Is it that bad that I want to take steps and spend money to avoid, or is it just something that I have to endure? Well, we're going to talk about all that today, and I hope that it will help you personally, you and your family, and I hope that it will help you professionally as you talk to clients and customers and patients and so on who are struggling with a lot of these issues that, well, all of us have to struggle with it sooner or later. Let's see if I can make this work. Here we go. I mentioned this because it's never a question about whether, if we're going to die. It's a question of when each of us are going to die. Our mortality rate for all of us is still 100%. So dealing with some of these issues now while we have our capacity and our energy makes a lot of sense, rather than waiting until the very last of our, last of our lives where we have lost capacity and energy and inclination and all that. So it applies to all of us, believe it or not. What is probate anyway? Well, probate is an arcane and mysterious topic. I'll put it that way. Everybody who comes in here has some vague notion about probate, but that's about as far as it goes. You know, I've heard the word, I've heard I want to avoid it, but I don't know exactly what it is. And I don't know why I want to avoid it, but everybody says you need to avoid it. Okay, so let's talk about it. Probate is this process that goes into effect when a person dies. When a person dies, they usually leave something behind. It might be a home, it might be money, it might be insurance, it might be stuff in the house, cars, boats, all that. That's collectively called an estate. Whatever you leave behind is called an estate. Probate is this process that has been cooked up by our states to make sure that that stuff gets to the right person at the right time. It also makes sure that any creditors that a person leaves behind when they die have an opportunity to get paid. It also provides an opportunity for Medicaid to be reimbursed for anything that they might have spent towards that person's care during the course of their life. It also is there to make sure that the courts get paid, their court costs and legal fees and all that. And finally, after everybody else gets paid, it's designed to pass the remaining assets to the right people at the right time. So if a person has a will, those people are called beneficiaries. If a person dies without a will, those people are called heirs. And you may have heard that term, heirs at law, or next of kin. That's another way that it's referred to. So if you have a will, the will generally tells the world who gets my stuff when I'm gone. If you don't have a will, that's okay. The state has one for you, ready and waiting. And it tells the world who gets your stuff. It may not be who you want to get that stuff, but you know, you had an opportunity to draft your will when you were alive, and the fact that you didn't do it, well, that means the state's will gets to dictate. So it usually goes to your spouse and your kids. If you have kids from a previous marriage, they all get an equal shot. If you have a charity that you support, well, that charity is not going to get anything from you if you die without a will. So having a will makes a lot of sense. Not many people, well, maybe half the people have them, half the people don't. So if you don't have one, at least it's a good first step to dealing with the probate process, because a will, here's something else I hear all the time. People come in here and say, well, I have a will, so I guess I'm going to be able to avoid probate. Not so fast. A will doesn't avoid probate at all. A will is a fast track through that process. It's a little cheaper, a little bit faster, but it doesn't avoid probate. So a will's better than nothing, believe me, but it's not going to help you avoid probate. There are certain steps you can take, and we're going to get into those, so you can share that with your family and so on. But just know right now that a will does not avoid probate at all. Probate can be avoided, but we're going to talk about that. So there are three ways, and as far as I've been able to tell in 40-something years of doing this, there are only three ways that your stuff will pass when you die. The first way, and the best way, is if you own an asset jointly. Now, a lot of husbands and wives own their homes jointly. A lot of husbands and wives might own their bank accounts or investments jointly. That's great because when the first person dies, it passes immediately and automatically to the survivor. They don't have to do anything, pay anything, file anything, talk to anybody. It's automatic and immediate. That's the best way. But not all assets are available to be owned jointly. The next best way is if you have a beneficiary owned asset. Now, you know, IRAs and 401ks, 403bs, life insurance, those all have places where you can name a beneficiary. Well, you should do that because if you have a named beneficiary on that asset, it's going to avoid probate and pass to that person virtually immediately. Now, it may take a couple of weeks in actual, time, but they don't have to hire a lawyer. They don't have to jump through too many hoops. It's going to be under the radar and free. So things like life insurance, 401ks, 403bs, IRAs, annuities, those all have beneficiaries on them. And those assets at least can be avoided if you have the beneficiary's name. The third way assets pass when a person dies, that is, if a person dies and their assets don't have a joint owner and they don't have a beneficiary. So let's say that your granddad, he's a widower now. He lives in his house. It's paid for. Nobody's on the deed but him, and he dies. That's a sole asset, and it's going to have to go through probate to get to the next owner. Well, who is the next owner? Well, it depends. If you have a will, the will might say who the next owner is. If you don't have a will, state law says who that owner is. But regardless, a solely owned asset like that's going to have to go through probate to get to the new owner. And probate is the process, we're talking about avoiding. So what can we do to avoid probate? There are two kinds of probate, by the way. We mentioned it a minute ago. Testate probate is the term referred to when a person dies with a will. Intestate probate, these terms will probably never come up again, so you don't have to remember them. Intestate probate is when a person dies without a will. Testate's better than intestate. So intestate probate, when a person dies having a will, there's minimal court oversight. There's still court oversight. You still have to pay court costs and all that, but the oversight's minimal. You have to notify, this is where it really gets kind of sticky. When a person first begins the probate process, you have to send out these letters to all of the next of kin, not the beneficiaries of the will. You would think that would be right. No, you send them out to the next of kin, and these waivers say, condolences on your recent loss. As you are aware, Joe Schmo passed away and you were one of his next of kin. And we're notifying you that his last will and testament is ready to be admitted to probate. And as a next of kin, you have the right to be there. But if you want to waive that right to be present, sign here, send it back to me, and you can avoid it. Well, that creates all kinds of problems because people think lawyers are trying to cheat them. So they don't send it back, and it slows the whole process down. But you have to notify next of kin, that's even illegitimate children. So if your dad, this came up with us a couple of years ago, dad had a child out of wedlock 60-something years before, and his wife didn't even know that child existed. Well, dad dies, and this guy shows up at the funeral. 60-something-year-old guy shows up at the funeral and was claiming he was the eldest son of this fellow who died. Well, he gets notified of that probate being open because he is next of kin, even though he was not referred to in the will at all. So those waivers have to go out as a first step. And sometimes it takes a while to get those signed waivers back. Letters testamentary, and I'm sure you've heard that term come up. Letters testamentary are official documents that the court sends to the executor. And those letters testamentary basically say, Joe Schmo's will was admitted to probate on January 5th, 2025. And Jane Schmo, his executor, has been appointed as the personal representative, and she has all the rights given to her by state law to administer that estate. So that's a formal document signed by the judge, and she can use that to open bank accounts, sell real estate, cash in other assets, whatever's necessary. So those letters are issued to the executor, and then 6 months has to go by, and that's called the creditor claims period. So 6 months give creditors, Visa, MasterCard, GMC, Brookwood Hospital, whoever, an opportunity to file a claim against the estate to get paid. A lot of people die with medical expenses, doctor's bills, and things like that. Well, they're entitled to be paid just like anybody. So they file these claims against the estate. And then after 6 months, all those claims are added up. And, we have a meeting with the executor and say, well, what do you want to do? Do these look legitimate? Do you want to pay them? You want to contest them or whatever? If they want to contest them, we get on the docket to have a hearing, and it may be 3 months down the road. But we can contest those if necessary. But mistakes get made, medical billings get confused, double billed. Maybe the code's been entered wrong, things like that. So that's what testate probate looks like. If you die without a will, you got to jump through all those hoops anyway. Plus, the person who wants to be the administrator of the estate, now with a will, they're called executor. Without a will, they're called administrator. Well, you have to be an Alabama resident. Well, to be an executor, you could be a resident of Lithuania. It doesn't matter. But to be an administrator, that is when a person dies without a will, you have to be a resident of Alabama. That's a problem for a lot of families because their kids have now moved away, and mom and dad still live in Birmingham, and the kids live all over the place, but not in Alabama. They can't even administer mom and dad's estate for them. So they have to get the county administrator involved, and their goal is not to save the estate money. They're out to make money. So another reason why you should have a will is to avoid the county administrator getting a shot at your mom and dad's or your estate. And then the final requirement there is the administrator has to be bonded in an amount 110% of the value of the estate. Well, a bond is a guarantee by a third party, like a bonding company, insurance company, something like that. And they say, we've evaluated this person who's applying to be administrator, and we think they're credit worthy. We think they're good for it. So we're gonna post a bond, $500,000 bond. And if they fail to do their job, if they run off with the estate's money, we'll go after them, but we'll pay the court, whatever the loss might be. Well, bonds can be expensive, and not everybody can get a bond because it's a credit decision. If you file bankruptcy, if you have slow credit, criminal record, those can all affect your ability to get a bond. So if you can avoid that bonding requirement by having a will, well, why wouldn't you? And the court is much more in your business when you're going through intestate probate than without intestate probate. So the court's literally making decisions every step of the way, and you have to go back to the court, ask their permission, and every time you go, it's a court cost and a legal expense. So yet another reason to avoid dying without a will. Where does all this take place? Well, it always takes place in the county where the person lived at the time of their death, which is kind of an odd way to say it. Their home county is where this takes place. And sometimes people will live in, say, Shelby County for their whole life and then move to maybe elite nursing care and spend a couple of months there before they die. Well, did they live in Jefferson or did they live in Shelby? Well, chances are they didn't vote in Jefferson. They didn't have a driver's license with a Jefferson County address. So we would do that in Shelby County. But that's, there's some wiggle room there. If there's some reason you would rather do it in one county versus another, we can look at that. What exactly does this executor or administrator do? Well, one of the things they do is they make sure that your assets that you left behind are protected. And sometimes that means changing locks on the doors of your home, to keep people, you don't know who might have keys to, let's say that you are the administrator for your sister's estate. Well, you don't know who your sister's giving keys to. It might be a cleaning lady, might be the termite guy, might be a neighbor. You don't know who that is. And you don't know what assets might disappear now that she's gone. So one of the jobs might be to change the locks, might be to post those game cameras around the house to make sure you can have a record of who's coming and going. Make sure homeowners insurance is paid up, make sure property taxes are paid so it doesn't go into some sort of default position. And make sure utilities are paid so that the house doesn't, develop mold or mildew, that kind of thing. And just make sure that you are the one now in charge of everything. You would deal with credit card bills and taxes and ultimately distribute what's remaining to the family, the next of kin, the beneficiaries, and so on. And that whole process takes time. It really does. And lawyers are supposed to help their clients at every step of the way, and we do, but I don't know if every lawyer does it that way. A will can be challenged, by the way, too, lack of capacity. Well, they had advanced dementia when they assigned this document. Do you think they really knew what they were doing? Or they were blind and nobody read it to them. They just said, sign here. Do you think they knew what they were signing? Or undue influence is another way, where maybe your mom lives with your sister, and your sister takes her literally everywhere she goes. Your sister won't let anybody talk to her unless your sister's in the room or on the phone. Your sister won't let your mom come stay with anybody else in the family. Well, is she exerting undue influence over your mom? Well, that's, could be. Especially if your sister's now convinced your mom to redo her will so that sister gets everything. Now, I think you could argue maybe there was some undue influence there. Also, the document itself could be invalid. That doesn't come up with lawyers drafting it so much as with people trying to draft their own will, but it can come up that it wasn't drafted correctly, the right wording wasn't used, might not be signed correctly, and so on. So quick timeline. Probate's open in the county where the person lived at the time of their death. The law firm will get it's an EIN, a taxpayer ID number for the estate itself. And that's not the same as the social, but it's basically telling the IRS, hey, this social security number is now converted to this new number because the person died, their social is no longer valid. Start using this number going forward. The executor would start consolidating assets. If there's CDs all over town, the executor may want to pull those CDs into one bank account so that bills can be paid and so on. Beneficiaries are notified of what to expect at the right time. And something that in the movies comes up a lot, in books, novels comes up a lot, but it doesn't happen. There is no such thing as a reading of the will. In movies, that people come into the lawyer's office to sit around a big table, and the lawyer unrolls his will and reads it to everybody, and they learn what they're going to get. Well, that doesn't happen in real life. I don't know where that, maybe in the 19th century or something, that's the way they did it. But I've been doing this for years, and I've yet to meet a lawyer who does that in Alabama. So don't expect it. In other words, people do call us and say, when's the reading of the will going to be? Okay, well, let me tell you something. It didn't happen. Continuing on our timeline, at the 6-month mark, that is after the creditor's claims period has run, then we decide what to do about creditors. If there's real property in the estate, it can now be disposed of either by being sold and the money distributed, or by being deeded directly to a beneficiary. If taxes have already been dealt with, and rarely have they, taxes need to be dealt with because the IRS wants their cut. After all that's been done, we file a petition with the court to settle it. And all said and done, it's going to take a year. It might take longer than that, but it takes at least a year from beginning to end, just so you know what you're looking at. What's the cost? Well, a year or more of your time, or the family's time, that's got some value to it right there. Possible creditors' claims, Visa, MasterCard, GMC, hospital bills, doctor's bills, so on, they add up. Court costs, which might exceed several $1,000s by the time it's all over with. And then your lawyer's fees, those are all coming out of the estate. So those are all the cost of probate, and they can add up. They really can.
Bill, I have a question.
Yeah.
So let's say that someone dies owing medical debt, which you contest, and that they still owe medical debt, or they owe taxes. What happens if the estate doesn't have enough money to cover that?
Sure.
Does it pass to the children?
Well, that's called an insolvent estate, when an estate has been opened and ultimately the assets aren't enough to cover all the bills. Well, those bills will get prorated among the various creditors, but there won't be anything left for the family.
Got it.
Nothing. So that's one of the initial questions we like to talk about. It's like, what do you anticipate the assets in the estate consisting of? You know, real estate, bank accounts, so on. Let's find out what the assets look like before we jump into this, because once you jump into probate, you can't back out. You gotta go the whole process. And the last thing you want to do is to get hired to help somebody with probate, and at the end say, there's no money left for you. I'm sorry you went through all this process and paid all this money, but there's no money left for you. So we don't want to have that conversation. We want to make sure at the front end there's going to be enough left over, so that doesn't happen. But it can happen. You're right. It really can, especially with insolvent or intestate probate. When a person doesn't have a will, the family might not know the specifics of how much they owe or what they own. It can happen there more than with a will.
But if there's nothing, there's nothing. Everybody loses.
Everybody loses.
Okay.
Even the creditors don't get 100 cents on the dollar. They might only get 70 cents on the dollar, depending on how many creditors there are.
Right.
But all of that can be avoided. I just want to make sure you understand that all of that stuff, probate, whether it's testate or intestate, can be avoided if you want to avoid it. Simple as that. Most people don't know how to. They know they want to, but they don't know how to. Well, here's how to. The easiest way to avoid probate is to be using trust as your tool. Now, most people think about wills as being an estate planning tool, estate planning document, and they are. They don't really think about trust as being an estate planning tool. They think of trust as something that rich people have, might own property, offshore in some, third world bank account somewhere. Well, trusts are much more common than you might think. And trusts are not just for rich people. Certainly rich people started the ball rolling years and years ago, decades ago, because they did have a lot of assets to protect. And income tax rates were much higher back then than they are now. But these days, really, it's not so much how much money you have as what type of asset you might have that would help dictate whether you need a trust or not. Trusts do avoid probate entirely if they're set up correctly and funded correctly. They're much faster. You could administer a trust in a month, whereas if you had to jump through the probate hoop, it's going to take you a year, no matter what you do. And many people think I'd much rather get this settled in a month than a year. A trust is also much more under the radar. When you open probate at the courthouse, everything that you do there is a public record. So anybody can go to the courthouse, pull that file, look at Mr. Schmo's will, see who his beneficiaries are, can even see what creditors have filed claims against the estate. And I mean, anybody can do that. With a trust, nobody can do that except the beneficiaries of the trust. So you don't have to worry about other people knowing your business. It's protected. It's confidential. And it's much harder to challenge a trust than it is to challenge a will, because there is no public proceeding. There's no court record to challenge. It's much more difficult. And many people like that because it's harder for a disgruntled family member who's been left out to challenge it. Modern trusts these days are used most often when a person owns property in more than one state. If you own your home in Alabama and you own it, you and your husband, you may have to go through probate here in Alabama. Well, if you own a beach place in, say, Florida or South Carolina, or if you own a mountain place in North Carolina or Tennessee, you're going to go through probate here in Alabama because you own a house here. You're also going to go through probate in Florida or South Carolina or Tennessee or North Carolina because you own real estate there. That's twice the cost and twice the delay. Well, you can own both of those homes inside of a trust and avoid probate in both states. Great. Saves you a lot of money that way. Trusts are also ideal for people who consider themselves famous. Now, that could be, legitimately like Nick Saban. I'm sure he has a trust. I don't know that for a fact, but I'll bet you anything he does. People like to, if you go to Graceland, you can see a copy of Elvis's will. They sell it in a gift shop. Um, I don't know. That just seems kind of cheesy to me that anybody can see what your will says. Well, a trust is great for famous people because nobody gets to see what you do with your stuff, but the people who are benefiting from it. It's also great for second marriage planning, where each of the spouses comes into the relationship with their own children, because many times they want to make sure everybody's treated fairly, but you don't know who the first spouse to die is going to be. So after the first death, the surviving spouse could remarry. Well, that may change everything. So when you have a trust, you can dictate at the front who's going to get what of, the children, regardless of what the surviving spouse might end up doing after the death of the first spouse. Even if you, I mean, I don't think it's ever too late for second marriage, third marriage couples to look at this. So it's a great way for them to make sure everybody is taken care of equally and avoid fights, because fights between stepkids, that's not unheard of at all. And finally, and lastly, you avoid probate with a trust. So you avoided all of these costs and all of this delay and all of this nonsense. So trusts are not something brand new by any means. They came about in the Middle Ages, actually, when the British were, they were going to the Middle East to fight in the Crusades. And back in those days, your wealth was tied up in your real estate, your land, the barons or whatever they were called, earls, dukes, I don't know that stuff. They owned all this real estate. They had all these serfs working the real estate to produce wealth for the landed gentry. And these landed gentry were the ones who were going to the Crusades to fight. So they knew that they might not come home. It was a long trip even back then. So they came up with this idea of a trust. They went to the bishop, who was, the clerical, big shot in each community, and said, "Bishop, I want to entrust my real estate to you. I'm going to go to Jerusalem and fight the folks over there. I might not come home. So here's what I want you to do. I want you to give this real estate to my eldest son if I don't return. If I do return, I want you to give it back to me." So the bishop held this asset, this real estate, in trust for the duke. Upon his return, he would give it back to the duke. If not, he would pass it to the eldest son so that the land stayed in the family. Well, that's the way trusts started. And that was what, like 1300? So they've been around a while. Same concept works now. You are taking your home and your beach house or your mountain home, maybe your millions of dollars of CDs, and you're entrusting that with a trustee. You're giving it to a trustee, and the trustee's job is to hold it under the terms that you specify and then distribute it at some point in the future. Well, in most trusts, you are your own trustee. Doesn't make sense, I know, but you're basically wearing three hats when you have a trust. You're the trustee of the trust. You're the person who gets to manage it and spend it. You're the beneficiary of the trust, the person who gets the benefits from the trust, the money and all that. And you're also the creator. That's called a grantor, the person who created the trust. So you're treating yourself as if you were someone else. You're saying, you're going to be my trustee. You're going to take action as trustee. And if property has to be sold, you sell it as trustee. If property is bought, you buy it as trustee, and so on. The trust usually will say specifics about what you want to have happen. With a typical married couple trust, Mr. and Mrs. Jones, let's say, they create their trust. Mr. and Mrs. Jones are co-trustees of that trust. And during their lifetime, they're the only beneficiaries of that trust. At their deaths, the trust would probably say something like, upon the second of us to die, our successor trustee, maybe it's one or all of their children, would step into that role, are to divide the remaining trust assets as follows. We have 4 children. We want those assets divided equally 4 ways. Something simple like that. That's how a trust works. It is a will substitute in a way. It avoids the I guess the disadvantages of having a will and the disadvantages of probate, but it still accomplishes the same thing. You can also delay gratification with a trust much better than you can with a will. And by that, I mean, let's say that you have teenage kids. And if something were to happen to you and your wife in the next 5 or 10 years, you are pretty sure that they're too young to manage assets in a responsible way. So you could say, I leave everything to my 4 kids equally. However, if any of those children are less than 30 years old, their share will be held in trust until they reach age 30, at which point it can be paid out. You can do it 35, 40, 45, anything like that. You hope that by 30 or 35, the child is mature enough to not go out and blow it on a Corvette or a Harley or whatever kids buy these days. So you can delay it that way. And you can have other things like special needs trust provisions built in there for kids or grandkids who have disabilities and so on. Very flexible, and really the sky's the limit. It's just the best way to do it is for somebody to come in to a lawyer and say, lawyer, I'm kind of thinking like this. Is that possible? And the lawyer would say, yeah, absolutely. Let's do it this way. Or I recommend that versus that. So it's a very flexible way to do your planning. None of this one size fits all business. Now, we saw this slide already, remember, at the front end. Why am I showing it again? Well, remember, there are 3 ways assets pass when a person dies: joint ownership, beneficiary designations, and if you don't have the top 2, got to go through probate. Well, I'm bringing this back because there are other ways to avoid probate besides using the formality of a trust. And some families, let's face it, they're not wealthy, they're not famous, they don't own property in 2 states, but they still want to avoid probate. Okay, how do we do that? Well, remember, joint ownership was one way that you can avoid probate. Well, how do you do that? Well, you can add your children to your bank accounts as joint owners with you. That asset would then pass to your child at your death without you having to have a trust and without you having to go through probate, because they're the joint owner. So after your death, they can breeze into the bank and withdraw all the money out of the account. Simple as that. That's the way to do it with joint ownership. You could also have your bank account set up as TOD or POD assets. Now, TOD stands for transfer on death. POD stands for pay on death. Wells Fargo calls it one thing, Regions calls it another. It's the same concept. What you're saying there is it's a designation that you put on your bank account. And it basically says, hey, Regions Bank, this is my money while I'm alive, but at my death, I want you to transfer it to my son, so-and-so, or my son and daughter. And so they don't have a claim to the money while you're alive, but at your death, they can walk into the bank and say, Mom died, and I think I'm TOD on her bank account. Here's her death certificate. Here's my ID. And if you are TOD, they'll let you know and they'll write you a check. The downside of TOD is, well, you got to tell your kids they are TOD. If they don't know to go to the bank to ask about it, the bank's not going to just send them a check. Also, TOD and POD accounts require a death certificate. Well, sometimes it takes 2 or 3 weeks, a month to get a death certificate. So the money's not available immediately that way as it would be if you were joint owner. Now you might say, well, it sounds like joint ownership's better, right? Well, not so quick, because if you are joint owner with your mom on her bank account and you have neglected to pay your child support for the last 10 years, or you have forgotten to pay your taxes for the last 10 years, your mom's money is at risk because the IRS or your, ex's lawyer can attach that bank account because it now has your name on it. And you wouldn't want to do that to your mom. I'm sure your mom wouldn't want you to do it to her either. So joint ownership puts your credit shortcomings onto your mom's bank account, whereas TOD doesn't. You can have joint accounts, though, with bank accounts. You can have them on investment accounts. You can have them on credit union accounts. Best thing to do there is to ask. If you have any questions, ask. Beneficiary designations are another way to avoid probate and avoid having a trust. Beneficiary designations, we mentioned, apply to IRAs, 401ks, 403bs, life insurance, annuities, And certain pension plans will have beneficiary designations. So the smart thing to do is to sit down with your loved ones and say, let's take a look at this. If we do need to change beneficiaries or add beneficiaries, let's do it now. I've seen people with IRAs that never had a beneficiary on. And really, anybody who sells you an IRA should be required to put a beneficiary on that for you, because otherwise it doesn't do you any good at all. So beneficiary designations are a great way to avoid probate and also avoid having to have a trust, because it's virtually, well, you still have to get a death certificate. You still might wait 2 or 3 weeks, but you'll still get the money without anybody else knowing about it. Lastly, and this is one that we see come up quite a bit, because people will oftentimes, as they get older, they'll add their kids to their bank accounts as joint or TOD, just so they can manage them for them, as mom and dad's capacity maybe declines. They can't get out as often. So it's not unusual for us to see the adult children on bank accounts. And it's not unusual to see the children on life insurance or 401ks. You know, that's the way it should be. But many people still own their homes individually, or just husband and wife. That one asset could drag the whole process back into probate if you don't deal with it. So the easiest way to deal with that is what's known as a life estate deed. A life estate deed is a special type of deed on real estate that says, I own my house for the rest of my life. I can do with it whatever I want to. If I want to bulldoze it, I can. If I want to add on to it, I can. But at my death, it immediately passes to whoever you have on the deed. So it's sort of like a TOD account, you know, acts. It passes to the new owner at your death. The new owner doesn't have any say-so while you're alive, just like on a TOD bank account. But it passes to that new owner immediately upon your death without having to go through probate. So it's a great way to deal with real estate. And when some families come to us and they've already taken care of all the other details, you know, joint accounts, beneficiary designations, and they have a home, I'll tell them, you know, yeah, we can do a trust for you. It's going to be however much it costs, but we can do a life estate deed, and that's 1/10 the cost of the trust and pretty much accomplishes everything the trust does. Which one would you rather do? Most people choose life estate deeds, as you might well imagine. So those are ways that you can avoid probate without having to go through the complexity of or the expense of a trust. Just so you know.
I have another question, Bill.
Yes, sir.
With all of those on the former slide, how do those impact Medicaid potentially?
Good question. Life estate deed is one of the few remaining techniques that we can use to protect your home from Medicaid. So if mom and dad own their home outright, dad dies, now mom owns it outright. If mom has to go to a nursing home, Medicaid's going to file a lien on the house. And at her death, that lien's going to be collected on the sale of the house. If that home is in a life estate deed, though, that has been in a life estate deed for 5 years before mom applies for Medicaid, the house is exempt from Medicaid's reach.
Really?
The kids, yeah. Great tool. I mean, if your mom's 90, we could try a life estate deed. Might work, might not work. But if she's 80, it might certainly work. Meanwhile, mom still gets to live there. She still gets the homestead exemption, and it still passes to the new owner with a step up in basis. So it's a great way to protect the house from Medicaid and also continue to keep mom's homestead exemption going. The joint bank accounts, they don't provide any Medicaid protection, and TOD certainly doesn't provide any Medicaid protection. With life insurance, yeah, you could be your mom's beneficiary of her life insurance policy, and she may be paying the premiums while she's alive. But if she applies for Medicaid, Medicaid won't let her use her money to continue paying those premiums on her life insurance. So sometimes the family will say, well, mom's been keeping this policy going for decades. We don't want to see it go away. Why don't we chip in every month and pay the premium, knowing that when she dies, it pays out to us? You could do that. And that's not uncommon at all. So just to wrap it all up in a nice package, there is no reason for people to go through probate. All those articles are right. All those podcast are right. You can avoid probate. There's no reason to go through probate. With a little advanced planning, you can avoid that whole nightmare and that whole expense, but you do have to plan. I mean, it's like anything else. You can't just hope that it happens when you die. By then it's way too late. The interesting thing is the cost of avoiding probate is cheaper than going through the probate process. You might think it's going to cost a lot of money to avoid probate, right? No, it's going to cost you more money to go through probate than to avoid it. So it's sort of like, you remember that old ad? I think it was a Delco or something. It was "pay me now or pay me later" was the catchphrase. And some guy, some mechanic saying, "You can pay me now, pay a little bit more for Delco products, or pay me later to get your engine changed." Well, it's sort of the same concept here. You can pay now to avoid probate. That's coming out of your pocket. Or you can pay later by going through the probate process, and that's not coming out of your pocket. It's coming out of your estate, but it's still coming out. So it's cheaper to avoid probate on the front end than it is to go through probate after your death. But people don't think about that. So that would be what I would leave you with. You don't have to go through probate. With modest planning, avoiding it's easy. And lastly, the cost of avoiding probate is oftentimes less than going through probate. So if you have any questions, call us, email us. I've been doing this for a while. Jennifer, who's been with me for 7 or 8 years, she's been doing this for a while. Valerie joined us this year. Valerie is a late to law school person. She was a school teacher, special ed school teacher for years before her kids grew up enough for her to say, "I want to do something with the rest of my life." So she went to law school, and she's probably, don't hold me to it, I'm guessing maybe 50, maybe somewhere around there. So she's a fairly new lawyer, but she's not a 25-year-old new lawyer. She's a 50-year-old new lawyer. And she's doing a lot of our marketing for us. You may have met her at some of the events, some of the networking events over the last couple of months. But either you can call any of us. We'll be happy to help. And there's no charge to answer questions. There's no charge to meet with clients. The way we do things is we try our best to quote a fixed fee rather than the old hourly billing that a lot of lawyers still stick with. Once we talk to the client, figure out what their needs are, we'll say, well, this is what we would charge for the whole thing, this flat fee. That way they know walking out, it's going to cost us this. It's not going to cost us $300 an hour for who knows how many hours. That doesn't really help you too much. So that's the way we do it. But I'm sure lawyers still stick with the hourly rate billing model. It's hard to shake that from a lot of law firms. So I enjoyed talking with you. And if you have any questions, now's the time to ask.
Tiffany Smith is asking, what does putting your home in a trust do in terms of protecting the home from Medicaid, or is this an option?
A typical if you talk to 1,000 people on the street who have trust, probably 990 of them are going to say, "I have what's known as a revocable living trust." That's the typical probate avoidance trust. It doesn't provide any Medicaid protection whatsoever. It's designed to avoid probate and maybe delay gratification for your family. The other 10 people would say, "We have an irrevocable trust." Well, an irrevocable trust does allow you to avoid probate for all the assets in the trust, but it has to be an irrevocable trust. It's a little bit more complicated than a revocable trust. But if it's in place for 5 years before you apply for Medicaid, all the assets in the irrevocable trust will avoid Medicaid's reach. Money, CDs, stocks, bonds, mutual funds, real estate, all of them, not just your real estate. So a life estate deed avoids probate and avoids Medicaid on the home, but a life estate deed doesn't provide any protection for the other assets, whereas an irrevocable trust would protect all the assets.
Would a revocable trust do the same?
No. A revocable trust is designed to avoid probate. It's not designed to provide any Medicaid protection.
Got you. For some reason, some folks are saying the survey is not working. I'm not sure why that would be. I've changed the closeout on it. Maybe I should just get rid of it altogether. Let's do that. So cut off date and time off. So the link should be working. I'll read it for those who are watching this on YouTube. And typically these videos get placed on YouTube within a week of when we, present them. And they'll typically be on the website at carepatrol.com under my landing page the next day. So you can, both sit for these and take them as CEUs or share them with family. So here is the Survey Monkey link, https://www.surveymonkey.com/lowercase r/ all uppercase letters F as in Frank, B as in boy, Q, H, X, X, H. And the password today is probate with a capital P, ROBATE. Thank you so much, Bill. There's many compliments on this. I'm going to try and get Survey Monkey working again. And I don't know if anyone else has any questions, but I think everyone was pleased to have it. Do you mind if we share your PowerPoint, Bill?
Oh, help yourself. Please do.
So y'all please use the link that I've put in the chat room and tell me if that's working.
Well, I appreciate everybody paying attention and listening. And again, please share a nugget or two with your family just to see if they can avoid, any unnecessary expenses and delays. People just don't know, and they don't know who to ask. So if we can help out, please let us know.
Right. And Bill's the right person to ask. As you all know, he's been doing this since 1982, which is probably as long as some of you have been around. I graduated in 85 and just planned my 40th reunion. I'm not sure why the link's not working, y'all. Let me, I've refreshed the page. I've changed everything about it. Let me try this. Let me try taking the password off. Where is that? Password protection off. Cutoff date and time off. Okay. I fixed it, y'all. I have fixed it. Bill was saying earlier that he was glad to have a technology expert like me on hand, to which I replied that he was in sore shape if that's the case, but I have fixed the survey. Someone please try and open it and let me know if it works. For some reason, it was closed. It works. Great. So again, you must do the evaluation to receive the certificate. I'll be sending those sometime in the morning. Nurses will post your hours for you. Again, this is 1.0 contact hour. Great information. Bill, again, with your permission, I'll send out your PowerPoint for people. And I'm going to share this presentation with my ex-wife, actually, Bill, because I know she's just redone everything and I want to make sure she's protected herself and the children. But anyway, glad to have you all here. Happy New Year. I hope it's not only a great week and great day, but a great year for all of you on the call. We'll be back in 2 Mondays. That's the 20th of January. And I'm still trying to get a presenter. We've been talking for some time now. Hopefully we'll have someone present on death doulas, which is a sort of new thing in dying. And you would think it is much what it sounds like, just like a birth doula for the dying process. And I think that's fascinating. And hopefully we'll get that presenter in.
I know somebody does that if you need.
There's a whole group of people who do it. This woman's actually with a center
Mhm.
But I may reach out. Let me know, Bill, because I may want that person.
Okay.
Yes, Ms. Calder, it's a hospice thing in most cases. It's a hospice thing, but I don't know that it's always Medicare hospice in the home. But it is something that people do. I think it's a paid service,
Mhm.
that you pay a fee or an hourly rate or whatever, but it's an add-on. It's not, in most cases, in most hospices, not offered, but it is in some. Well, that's a wrap up for today, y'all. Thank you again for being here, Bill.
Thank you, Sean. Appreciate
All
it.
right, y'all take care.
Bye-bye.
Bye.